You didn't cause the crash, but now you're buried in paperwork, chasing repairs, and trying to figure out who's actually going to pay your medical bills. Meanwhile, the insurance companies are already working behind the scenes to protect their bottom line, not yours. I'm Doug Burnetti, a Florida personal injury lawyer, and I've been handling these personal injury type cases for over 30 years. And I'm going to walk you through the exact claims process after a not at fault accident, step by step, no fluff, so you can protect your rights, avoid costly mistakes, and get what you're legally owed. Step 1. Making sure everyone's safe and reporting the accident. Before you do anything else, you want to make sure that everyone involved in the accident is safe. In Florida, if you're in a car accident, call 911 if anyone is hurt or if the crash is serious, like when cars need to be towed or there's property damage. Even if it's just a fender bender and nobody seems hurt, Florida law says you need to report the crash to law enforcement if there's more than $500 in property damage. That's not much these days. It's easy to get $500 in property damage with just a few impacts. So it's always smart to play it safe and call the police. Why does this matter in a not at fault accident? Because having an official police report is like gold when it comes to starting your claim and proving you weren't the one responsible. It's your first piece of evidence. Officers will talk to everyone involved, maybe some witnesses, and then they'll write up what happened. Even if the other driver is saying sorry or admitting fault on the scene, you want a neutral third party documenting it. Sometimes stories change, especially after people talk to their own insurance company. If you're able, take photos of the scene. Snap your car from all angles, the other driver's car, the roadway, any skid marks, or even the weather conditions. If there are witnesses willing to talk, politely ask for their contact information. These details might feel small now, but can make a huge difference later. Step 2. Get medical attention even if you feel fine. Here's where I see people making a big mistake. They feel okay after the crash, so they skip going to the doctor. In Florida, we have what's called personal injury protection, or PIP insurance. Basically, your own car insurance covers the first $10,000 of your medical bills, no matter whose fault it is. But here's the catch. You only have 14 days to seek medical care for your injuries, or you risk losing those benefits. That means even if it's just a sore neck or a headache, go get checked out. Some injuries don't show up until hours or even days later. Things like whiplash, concussions, or soft tissue injuries might not hit you until your adrenaline wears off. If you wait too long, the insurance companies may argue that your injuries aren't related to the accident. Take care of your health first, then your claim will be much stronger. Step 3. Notify your insurance company and be careful what you say. You've called the police, you've seen a doctor, now it's time to call your own insurance company. In Florida, you're required to notify them about the accident, even if you were not at fault. Your policy will usually have a deadline, sometimes as short as 24 hours, so don't wait. When you call, stick to the facts. When and where it happened, who is involved, what the police report number is, and whether you're hurt. Don't guess about injuries, don't minimize or exaggerate anything, and don't say it was your fault. Let the investigation handle that. If the other driver's insurance company calls you, be polite, but remember, you are not required to give a recorded statement. Their main goal is to protect their own money, not yours. You can simply say you're going to consult with an attorney first before you talk to them. Step 4. Understanding insurance in a Florida not-at-fault accident. Let's talk about how the claim process actually works in Florida. We're known as a no-fault state. Here's what that means for you. Regardless of who caused the accident, your own insurance through PIP covers your medical bills and some lost wages up to $10,000. But if you're seriously injured and you are not at fault, you have the right to make a claim against the other driver's insurance for damages that exceed what your own PIP insurance covers. That might include things like medical bills beyond your PIP insurance, lost wages that are not fully covered by your PIP insurance, pain and suffering if your injuries are serious under Florida law, like a permanent injury or a significant disability or a disfigurement, property damage to your car, which usually that's handled separately by the at-fault driver's property damage liability coverage. Let me give you a real-world example. Say you're stopped at a red light in Tampa and someone rear-ends you because they were texting. Your medical bills end up at $25,000. In that scenario, your PIP covers the first $10,000, leaving $15,000 unpaid. You would then make a claim against the other driver's insurance for that extra $15,000 plus anything else you're entitled to, like pain and suffering, disability, disfigurement, loss of capacity for the enjoyment of life, or any other injury that would meet that legal threshold. Step number 5, what about rental cars and repairs? A question I get a lot is, my car is in the shop and I need to get to work. Who pays for my rental? In Florida, property damage liability insurance is required, but not every driver carries rental coverage. If the other driver's insurance accepts fault, they should pay for your rental car and repairs. But sometimes they drag their feet or argue about liability. In those cases, you may need to use your own insurance if you have rental coverage, and have them go after reimbursement from the at-fault driver's insurance later. If your car is declared a total loss, Florida law says the insurer has to pay you the actual cash value of your car right before the accident, not what you paid for it. If you disagree with their evaluation, you can negotiate or bring in evidence like recent repairs, upgrades, or listings for similar cars in your area. Step 6, the claims investigation process. Once you've filed your claim, both insurance companies will open investigations. That can mean phone calls, forms to fill out, requests for medical records, and sometimes even in-person interview. The at-fault driver's insurance will especially be interested in whether you had any prior injuries or pre-existing conditions. Don't be alarmed by this. It's standard practice for them to try to find that out so that they can try to hurt your claim later with it. Here's a tip. Don't sign any paperwork the other driver's insurance sends you, especially anything called a release, without talking to an attorney. If you do, you might be giving up your right to claim future medical bills or damages you don't even know you have yet. You may also be asked to provide a recorded statement. You are under no obligation to do this for the other driver's insurance. If you're feeling pressured, that's a good time to get legal help. Many insurance adjusters will sound friendly, but their goal is often to save the company money, not to make sure you get what you need. Step 7, medical bills and letters of protection. What if your medical bills go way beyond the $10,000 of PIP insurance that you have, and you can't afford to pay out of pocket while you wait for your claim to settle? In Florida, your attorney can help arrange treatment with doctors who will wait to get paid from your settlement when the case resolves or after a jury returns a verdict. So in that case, you can keep treating without worrying about collections or credit damage. This can be a lifesaver if you need surgery, physical therapy, or ongoing care. Step number 8, settlement or lawsuit. How do claims really end? Most not-at-fault car accident claims in Florida end in a settlement, not a court battle. Your attorney will gather evidence, medical records, police reports, witness statements, photos, and sometimes expert opinions to build your case. They'll calculate your damages, send a demand letter to the at-fault insurer, and negotiate from there. Sometimes the insurance company makes a lowball offer, hoping you'll take it because you need the money now. But you don't have to accept that first offer, especially if your injuries are serious or you're still recovering from your injuries in treatment. Your attorney's job is to fight for what's fair. If negotiations hit a wall, the next step is a lawsuit. Even then, cases often settle before reaching trial. The key is having all your evidence ready and knowing what your case is truly worth. Step 9, what if the other driver has no insurance? Unfortunately, not everyone on Florida roads is insured, even though it's legally required in some circumstances. If you're in a not-at-fault accident and the other driver has no insurance or not enough, you may have coverage on your own policy called uninsured or underinsured motorist coverage. We call that coverage. This kicks in when you're hit by a driver who can't cover your damages. It's optional in Florida, but I always recommend it. It's a safety net you don't appreciate until you need it. So if you're buying insurance for your vehicle, buy as much uninsured motorist coverage as you can reasonably afford. Step number 10, common mistakes that can hurt your claim. Let's quickly run through a few common mistakes I see people make after a not-at-fault accident. Not calling the police or getting a report. Admitting fault, even casually, like saying, "I'm so sorry." Delaying medical treatment, giving recorded statements without legal advice, signing releases or paperwork from the other driver's insurer, posting about the accident or injuries on your social media. Every one of these can weaken your claim, cost you money, or even prevent you from getting compensated. Takeaway, what you should do next. In a nutshell, the process for a not-at-fault car accident in Florida is about protecting your health, your finances, and your peace of mind. Make safety your top priority. Get medical treatment right away to protect your rights. Report the accident, document everything, and notify your insurance carefully. Understand your options for repairs, rental cars, and medical coverage. And above all, don't go it alone if things get complicated. Remember, insurance adjusters do this every day for a living. You probably don't. Often you need a lawyer to help you negotiate that. If you want to make sure you don't miss a step, or if you're already dealing with pain and bills, talk to an attorney who deals with Florida car accident claims every day. You shouldn't have to worry about paperwork or fighting with insurance while you're trying to recover. You need to be concentrating on your health. If you found this helpful, you'll want to watch our next video, How Do I Know My Car Accident Injuries Are Enough to Hire an Attorney? That video will walk you through exactly when you need legal help and how to recognize injuries that can change your case. Don't wait until it's too late. Protect your rights and your future. See you over there.